Okay. Thank you, Jaleesa. Hi, everyone. My name is Reginald Thomas. My pronouns are he, him, and his. I am the Senior Program Associate with the ARC of the United States, and I'm joined today by my co-presenter. I'll let her introduce herself.
Hi, everyone. My name is Ariel Sims. My pronouns are she, hers, or they, them. I'm the Senior Program Manager and Attorney, and I work on access, equity, and inclusion, and a few other initiatives at the ARC.
So welcome all to the Criminal Justice System 101. This is a Know Your Rights series. This is part 1 out of 3 webinars. We have 2 upcoming webinars. Well, our second webinar, Know Your Rights as a Person with a Disability in the Criminal Justice System, that will be held on June 4th. And our last webinar, Criminal Justice and Self-Advocacy, will be held on June 17th. So mark your calendars and get ready for those. So I want to kind of gauge where you're all joining us from. Across the country, I know we're all stuck at home due to COVID-19. So I just wanted to know who's joining us all today. So there is a poll at the bottom of the screen. Just click that and then enter in where you're from. So as a reminder, use the poll and not the chat function for that. Okay, Ariel, are you able to pull up the poll results? Okay, it seems like that we have a lot of people from the South. We have a few people join us from the Northeast. So, second place is the Midwest. And then we have other, not second place, sorry. Third place is to the Midwest, and second place is to the West Coast. All right, is there anyone here from Florida? You can put that in the chat box. I kind of want to know. Awesome, I see someone from Florida. What about from Michigan? Oh, I see there's a lot of Michiganders here. See some Texans. Okay. Well, I am happy that you all are able to take the time to join us for this webinar. Thank you for your responses. And then we can continue.
All right, just in case any of you joined us late, all attendees are muted and all attendee video is turned off. So we can't see you, but you can see us. So you have the advantage there. You do have the option to turn on closed captions. Those are at the bottom of your screen. Just make sure you select closed caption and then show subtitle. As you may have also noticed, we do have American Sign Language interpreters on the call today. We have them spotlighted, so they should always be showing on your screen. We will need to take short breaks periodically to change out the interpreters and give them a break. So when we reach a good stopping point for that, we'll pause and just ask everybody to hang with us while we switch out the interpreters. If you're having any technical problems during the webinar, you can visit support.zoom.us or type in the chat box and Jaleesa will try to assist you. The webinar today will be recorded and archived, including the PowerPoint and a transcript from the webinar. you are interested in other events or webinars happening at the ARC US, please email events@thearc.org, and we'd be happy to tell you about our upcoming events.
So I would like to thank the People with Disabilities Foundation for making this webinar possible. If you're unfamiliar with this organization, the People with Disabilities Foundation provides advocacy for people with all types of disability, the opportunity to have access to equal opportunities in all aspects of life. Now, a little bit about the ARC of the United States. If you're unfamiliar with the ARC, this is the organization that Ariel and I work for. The ARC of the United States is the largest disability rights grassroots organization in the country. We have over 600 chapters, both state and local, that are found almost everywhere on this country. And we also work for our criminal justice division that is called the National Center on Criminal Justice and Disabilities. And what we do in this organization within the ARC is that we advocate at the intersection of disability rights and criminal justice reform. Now, you're joining us today for this webinar, and I hope you all will be able to take in so much information and a new perspective about the criminal justice system that you may not have known before. So after this webinar, we'll hope you all will understand, like as a person with a disability, how you may get involved into the criminal justice system. And we want to help you identify the stages within the system, such as knowing when you first contact with a law enforcement, or what happens if you get sent to jail, what happens if you have to go to court for a trial, and then what happens after that. So we'll break it down for you in this webinar, and we'll also show you like what are the paths for a person who goes through the criminal justice system. And lastly, I want you all to know about the roles of the workers who are in the system. We have law enforcement officers, different legal professionals, and victim advocates, all who work together to ensure that we all have access to justice.
All right. So I'm going to start things out with giving an overview of how we think about the criminal justice system. And one thing that's important to note is that there is no one criminal justice system. Here in the United States, we have many different systems that are operating to hopefully achieve justice. We have a system at the federal level. We have systems that exist in every state. And we also sometimes have systems that operate at local levels in communities. So the information that we're sharing today is broadly applicable, so it works for most places, but it won't always work. But we still think it's helpful to provide an overview of what the criminal justice process looks like and how people can expect to move through the system and who they might encounter. So in our work, we use something called the Pathways to Justice model to help us figure out and simplify what can be a really complex system. In our model, we break it down into 6 different stages, and we also think about 2 main pathways that people can take through the system. So let me start first with kind of the big picture overview of the stages. First, we have first contact with law enforcement. Second, an investigation phase when a crime has occurred. Third, jail. Fourth, trial or a plea agreement. Fifth is incarceration. And number 6 is transition. That means transitioning back into the community. Now we know that people with disabilities are overrepresented in any criminal justice system. And we also know that people might interact with the system in different ways. So we're going to highlight a couple of ways that people might be involved, both as, say, a victim or a witness, or a suspect or defendant. And we're going to talk more about what each of those mean. So let's start with roles within the criminal justice system. So this is how you could be involved in the system yourself. Now, we are talking about the criminal justice system. So what we're really kind of saying is that at any given moment in time, a crime might happen. And I want you guys to give me an example of what is a crime in the chat box. So you tell me, what's a crime in the chat box? You can give me an example or a definition. All right, you guys are great. You're listing all sorts of things. So I'm seeing theft, assault, murder, rape. We have auto theft, driving under the influence. You know, I'm very suspicious now how knowledgeable you all are about different crimes. Okay, I'm really just teasing you all. But you're right, absolutely. So we call something a crime if it's against the law, if it's something that's wrong because society has says it's wrong, okay? So when we're talking about the criminal justice system, we're talking about something has taken place that really shouldn't have, or something that is not okay. And when a crime happens, there are often some different ways that people might be related to that. So we're going to go through each of these, but let me start with just a brief overview. Sometimes when a crime occurs, somebody gets hurt, and we would call the person who gets hurt a victim. And sometimes the crime is a result of somebody's action, somebody doing something. And if the person is, say, committing the crime, we might call them a suspect. And then a little bit later in the criminal justice process, we would call them a defendant, and I'll explain why. And then we might also have a kind of a third group here of someone who might have seen the crime occur. So there was a great example in the chat box about somebody stealing a cell phone from somebody else. Let's say that happens on a public bus. The person who had their cell phone stolen, that would be the victim. The person who took the cell phone from that person is the suspect. And say the person across the aisle in the bus who saw this happen, they would be the witness. Okay, so we're going to just go through these a little bit more in depth. So when we think about a suspect and a defendant, we usually are thinking about the same side of the system, but at different points in time. So when a crime first happens, we're typically looking for a suspect, someone we think did that crime, someone we think committed that crime, but we're not always sure that they did it, right? So you may have heard on like some great crime TV shows, law enforcement shows, right? That they were looking for the suspect. So that's when we call it when we don't necessarily know who did it, or that person hasn't gone through the formal process yet. So they haven't actually been what we would say found guilty of a crime. Now, once our suspect is actually, let's say, arrested by law enforcement and charged, we would call them a defendant. Now, charged is just a fancy way of saying that the state will tell the person what they think they did wrong. So coming back to our stolen cell phone example, the state might say the charge is theft. So that person now will be a defendant. They've been arrested, they've been charged with theft, and they're going through the rest of the process. Okay, recall that our victim is the person who is hurt because of the crime that happens. Now, this can be something that's a direct harm, right, or being directly hurt. So some of you were putting examples of, say, assault, where someone might physically hurt you, things like sexual assault, but it could also maybe be indirect. Maybe somebody is stealing Social Security checks and they didn't actually sort of hurt your person or your body, but they're still causing you harm. So a victim can be a victim for lots of different reasons, but generally speaking, we're talking about someone who was hurt because a crime happened. Okay, and that third kind of party I wanted to mention is the witness. So remember, this is our person on the bus who saw the cell phone get taken. So they weren't directly harmed. They weren't the person doing the harming, but they did see it happen. So they also have an important role to play in the justice system. And often they might be able to help someone get justice for themselves when they've experienced a crime. All right, so we have another polling question for you, and hopefully the geography one got you all warmed up. But the question is, what do you call someone after they have been formally charged with a crime? Go ahead and take some time for you to fill that out. And then Jaleesa, when you're ready, you can share the results, but give people a few more seconds. All right, perfect. So it looks like about 83% of you got it. It was a little tricky, but yes, a defendant. A defendant is what we call someone after they have been formally charged with a crime. Remember, a suspect is somebody that we're actually maybe not quite sure that they did what, maybe people are saying they did, and they haven't necessarily started through the formal process of the court system itself. So absolutely, defendant is the correct answer. Nice job. Okay, with that, we're switching gears to the key players in the criminal justice system, and I'm going to turn it over to Reggie.
Thanks, Ariel. So we learned about the different roles that a person who enters in the criminal justice system may play, but there are key players who work within the criminal justice system that you will interact with throughout the system. And the first one being a law enforcement officer or a police officer. Now, a law enforcement officer or a police officer is a person who enforces the law. So you'll probably see a person more than likely will have a uniform with a lot of badges, a holster with a gun, taser. We do have officers who aren't in uniform but are still on duty. But we just want you to recognize who an officer is. And these people will help in emergencies, and they will help when someone is hurt or when a crime is reported. Law enforcement officers or police officers will also investigate crimes or criminal activity. A victim advocate, instead of investigating crimes or focusing on suspects and defendants, a victim advocate will help a victim of the crime. So they will support crime victims and help victims find needed resources within their area. And they will also help prepare a victim for court. Now, we're going to talk about several types of legal professionals, but each of these persons are very important and you should know. A defense attorney is a lawyer who represents and advocates for the defendant, who is their client. Now, a defense attorney will also explain the law to their client. We all know that the law can be very confusing, and a person who is not trained could not really understand it. So a defense attorney helps break down the laws for their clients and also help their client understand which is their best legal option for them to take within a criminal case. Now, on the other side, a prosecutor who doesn't represent the defendant but represents the state in the case decides what charges to bring against the defendant. Now, a prosecutor will work with the victim and maybe sometimes witnesses as well. And these are the people who will try to bring the case against the defendant. So just kind of see the same side. They're both lawyers, but think of it as two sides of the same coin. One is for the defendant, and one usually represents the victim. Now, a judge is the one who oversees any legal proceedings, all court cases, all trials. Judge is a person who will listen to the testimony that's given by the victim or witness, and the judge will instruct other key players, such as the defense attorney, prosecutors, law enforcement sometimes, on court proceedings, and will also decide the sentence for the defendant. So the judge is the one who sees everything go down and actually make sure that there is fairness within the legal system. So I have a question for you all. And now for my polling question is, true or false, a law enforcement officer will always help you? And Jaleesa, whenever you're ready, you can post the results. We're just going to give some of the attendees time to answer the question. Okay, I see that there was almost even split. The answer is false. A law enforcement officer will not always help you, and I'll explain why. Pretend that you're a suspect in the case. A law enforcement officer's duty is to find out who committed the crime, and if you are a suspect and you have committed the crime, the law enforcement officer's duty is to arrest you and to take you to jail. So your interest and the law enforcement officer's duties may not align all the time. So I want you all to be aware of that. And it seems like we are getting ready for our American Sign Language interpreter change. So we're just going to take a few moments for that to begin. Okay. Are we good to go? Awesome. All right. So now we're going to break down the stages of the criminal justice system. Now, we're going to allude back to our Pathways to Justice model that Ariel has showed, and she's going to break it down on how the stages of the criminal justice system works for both a defendant and a victim in a criminal case.
All right. Thanks, Reggie. So you might recall that we started out with how you might get involved in the system. We talked about you could be a suspect, a defendant, a victim, or a witness. And then Reggie just reviewed some of the key players within the justice system. Sometimes we call these folks criminal justice professionals. He talked about law enforcement, victim advocates, and a few different types of legal professionals that you might encounter, including a defense attorney, a prosecutor, and a judge. So now we're going to kind of try to put everything all together and look at the actual process or the stages of the system that you would go through. And we're going to do this kind of twice. We're going to start on the suspect defendant side of the equation and go through the system that way. And then we'll flip it and talk about what the experience might look like on the victim side. So it's the same stages for both, but the experience looks different depending on how you're interacting with the system. So first, let's revisit the actual model and the stages. So I just want to give you a brief overview again of each stage before we go into a little bit more depth. And remember, people with disabilities and everybody can get caught up in the system in different ways. You know, at some point they could be a victim, at some other point they could be a suspect or a defendant. So there's sort of no guarantee that you would only interact with the system in one way. So we'll keep that in mind. Okay, some brief overviews of the stages themselves. We'll start with first contact. Again, this is first contact with law enforcement. It's very, very common that in order to kind of get into the system, regardless of how you're doing so, that you're going to interact with law enforcement, right? There's someone that maybe will get called if somebody needs help. Maybe it's an emergency, maybe somebody experienced victimization, or if someone suspects somebody of doing something wrong, they might call law enforcement in their public safety capacity that Reggie was just talking about, right? But they're one of the biggest entry points here. You may have also seen in the news things about people, say, being arrested in schools or taken away from schools. That often means that people are still interacting with law enforcement, just maybe in a different way. So after that first contact, there's usually an investigation period. So we think a crime has occurred. We're not really sure what happened, but we're trying to figure it out, right? And the criminal justice system is activated at that point, and they're trying to figure out, well, who is the suspect and should they be a defendant? Was there a victim? You know, what happened to the victim? Who saw this? Were there any witnesses to what happened? So it's a really busy time in the process because they're trying to put together the story of what happened. Now, let's say that they do find that a crime did occur. Then if there is a suspect, they might take that person to jail. So we talked before about being arrested and taken to jail. So that could happen at this point. Now, that's on the defendant's side, but there are other things happening on that side for the victim, which we'll come to in just a few minutes. Now, after the investigation and perhaps that initial jail time, then we have trial or plea agreement. So this is when the system is kind of formally deciding what's going to happen because of the crime. So is someone going to get punished for what they did? You know, what's going to be the outcome of this, of what happens? And that really looks at the laws in a particular, what we would call a jurisdiction or a location. So you know, it could be something in the federal system, and we're looking at federal law, or it could be a state criminal justice system, so we're looking at state law. Now, after that, if the person who was now a defendant is found guilty, so that means the system decided that they did something wrong, they might get punished, and punishment could look like being incarcerated, being taken to prison or jail, and not being able to leave, right? And again, that's a little bit more on the defendant side, but we'll also talk about what that might mean on the victim side. And then this transition period back into the community. Many people who go into the criminal justice system will come back into the community. So it's not like people go into the system and they always stay there. They will come back out into the community at some point, and it's possible they might go through the system all over again. But there's usually this transition period between that time and coming back into the mainstream community. So keep these stages in mind as we walk through then each side of the system and get a little bit more detail. Now to do this, we're going to use a little bit of storytelling to make it a little easier to understand sort of what's happening at each stage. And we have two different stories to tell you, one about a suspect defendant and one about a victim. And we'll start with the suspect defendant story, and then we'll switch after that. Okay, so we're going to talk about Sam. So on this side of the system, the suspect defendant side, we'll start with Sam, and we'll just say Sam is a person with a disability. And Sam, you know, he really loves cars, and one day he breaks into a car. So maybe saw something in the car that he really liked, and maybe smashed a window to get into the car and look a little bit closer at what was in there. Now, breaking into cars is illegal, right? It's wrong. We're not supposed to do it. And someone saw Sam do this, you know? So again, that person is our witness, right? Someone who saw a crime possibly take place. And our witness who saw Sam break into the car calls the police. So this really kind of triggers that first stage, right? First contact with law enforcement. So typically if someone is calling the police and saying, I saw somebody break into a car, they're going to send a law enforcement officer to the scene to figure out what's going on. So the law enforcement officer would come on the scene. They would talk to Sam if Sam is still around. They would talk to the witness, the person who called in kind of the complaint about what happened. And then if the law enforcement officer believed that Sam did indeed do this and broke into the car, probably Sam's going to get arrested, right? So the officer is going to put Sam in handcuffs and take Sam to jail. And sometimes we call this process booking, taking someone, arresting them, bringing them to a jail or other kind of detention facility. Basically, we're starting the formal criminal justice process when we do this. And as I said, it really starts with law enforcement most of the time. Okay, so poor Sam, he got in trouble, right? So he was arrested, he was taken to jail. And now while Sam is in jail, kind of maybe waiting to see what happens, there is going to be some investigation happening. And in this case, the law enforcement is going to be working with the prosecutor. You might recall that the prosecutor is the person who is going to kind of make the case against Sam. And the prosecutor also has to decide what charges are the right charges for Sam. So remember, formal charges is just the way that the state or the other kind of criminal justice system we're talking about tells the defendant what they've done wrong. Okay, so in this case, maybe they would say it was a vandalism charge because Sam broke a window of the car. So the prosecutor will work with law enforcement. Law enforcement will report out on sort of what they experienced or saw at the scene, why they think Sam is the right person who did this, and the prosecutor will figure out the charges, and then we'll work on actually bringing those charges against Sam. Now, there's also going to be an opportunity for Sam to have what in most places is called a first appearance. This is when Sam is given an opportunity to respond to those charges. So the state says, you committed vandalism, and Sam has the opportunity to sort of reply. And there are generally 3 types of reply that Sam could do. He could say, no, I didn't do it. Typically, we say this is not guilty. Sam could say, I did do it, so that would be a guilty plea. Or in some places, you can plead no contest, which means I don't really want to contest the charges. I don't want to argue with what the state is saying, but I don't want to formally plead guilty either. So it's sort of in the middle, in between. Now, in some places, Sam will already be represented by a defense attorney at the first appearance. In other places, sometimes it'll take a while before the defense attorney could be there and actually help Sam with this process. So that's the kind of the investigation phase and the point where we start to take Sam as a suspect and see him become a defendant. Okay, let's talk about jail. So in some places, there's a system where you can pay money and you can kind of get out of jail before a formal trial takes place. So we call this bail. In other places, they have sort of different kind of pretrial services involved. But in our kind of example here, we're going to pretend that we're in a place that uses bail. And Sam, let's say he doesn't have money for bail, which is very, very common, right? So if Sam doesn't have money to pay to get himself out of jail, he's going to have to stay there until his trial. And that could be a few months, right? And usually at some point, if the defense attorney has not already entered the scene, they are involved at this point. So maybe they're meeting with Sam for the first time. They're starting to advise Sam on what's going on in the case and hopefully helping Sam figure out what would be a good outcome in this particular situation. All right, and then we get to the formal trial process. So remember, this is the really formal part of the justice system where the state or the government is deciding what happened and whether or not someone should be punished, right? So it's a very serious part of the system. And through this process, we can have what's called a trial where we have this very, very kind of formal opportunity for people to share stories about what happened. We call this testimony. We might even have the law enforcement officer come in and talk about, what was in the law enforcement report. We might have that witness come in who called the police in the first place. They might be providing testimony, right? And the judge is kind of overseeing all of this activity that's happening. And as Reggie mentioned, we have the prosecutor who's representing the state basically saying, Sam should be found guilty, right? Sam did something wrong. Here's what Sam did wrong. And on the other side, we have the defense attorney who's really, in many ways, kind of speaking for Sam and trying to defend Sam, right? Trying to get Sam out of trouble as much as possible. But in our case, unfortunately, let's say Sam was found guilty. If Sam is found guilty, then he would go to a sentencing phase. And in our scenario, we're going to say that the judge is going to sentence Sam to 3 years in prison. Now, some of you are probably in jurisdictions or in communities where there are juries and jury trials. That can happen in different places. Sometimes we ask a jury or a group of people to decide whether or not someone is guilty. So we would call that a jury trial. In other places, it's just the judge who gets to make that call, and we'd call that a bench trial. And then usually in most cases, regardless of who is determining guilt or innocence in this case, the judge then makes a call on how long a person would be in prison, say, or what the punishment or outcome should be. Now, trials, I'm sure everyone has seen Law and Order or some other kind of, shows where you kind of see what it looks like maybe at a formal trial. This is actually not very common. It's not very common for there to be an actual trial. Instead, most criminal justice cases here in the US are kind of resolved by plea agreement. Now, plea agreement is a really fancy way of saying that the prosecution and the defense make a deal. And typically the offer is coming from the prosecution, and they're saying, tell you what, if Sam pleads guilty, I'm only going to recommend to the judge that he spends 6 months in jail and then does community service. And then the defense attorney's job would be to take that back to Sam, talk it over with Sam, make sure Sam understands the consequences of that and what's in there. And then Sam should make a decision on whether or not he wants to do that, right? And the reason that there's a lot of reasons that people might choose to do a plea agreement as opposed to going through trial. One is around the uncertainty of a trial. You might go to trial and be sentenced to prison for a very long time, and it might feel better to maybe plead to lesser sentence, so something that's shorter and guaranteed, as opposed to going to trial and really not knowing what's going to happen. So that's one reason, but there are many, many others. Now, regardless of whether it's a trial or a plea agreement, we sort of get to a formal outcome. And for Sam, we would call this most likely a conviction, right? If Sam is found guilty, whether Sam pleads to that or because he's found guilty at a trial, that would be sort of the outcome. So Sam would be convicted, that's what we would call it. And then, of course, he would have to go through the punishment phase, right? So in this case, he's found guilty and the judge sentences him to 3 years in prison. So let's talk about incarceration. So the judge made that sentence. Now Sam is taken to prison and he actually only stays there for 2 years. He was sentenced to 3, he stays there for 2. This is very, very common here in the US that people don't necessarily, what we would say, serve their entire sentence, right? Sometimes it's because our jails and prisons are overcrowded. Sometimes it's because people, while they're incarcerated, they have very good behavior, so the system will let them out early. So in Sam's case, he doesn't actually go to prison for the full 3 years. He does 2 years. Now, while Sam's in prison, I just wanted to highlight some things that you can expect in a prison environment. Now, in a prison, people live there full time, right? And they can't leave. So it's not a good or fun place to be. And within the prison, you can be housed in different places. You might be, say, housed with everybody else. This is something that we would call general population. Or you might be by yourself. And sometimes we call this segregation or administrative segregation, or sort of the most colloquial name is solitary confinement, right? Those are all issues. And other places will actually have different levels of housing unit, maybe for those who committed, say, more serious crimes. So, going back to some of our examples earlier, someone who stole a cell phone likely is not going to get the same level as punishment as someone who, say, assaulted somebody else or killed somebody, right? Those are a lot more serious, and they're likely going to have a lot bigger punishments than something as simple as taking a cell phone. Okay, I saw in the chat box a question about, well, what if Sam has guardianship? And that's a great question. Guardianship is a civil system, is something determined in the civil system. And usually we're looking at the question of, does Sam have the capacity to make his own decisions, right? That's a key question when we're figuring out if someone needs to be under guardianship. Now, if the answer to that question is Sam does not have capacity, he might end up with a guardian. But in most states, that is a civil determination, and that finding stays in the civil system, and it does not necessarily carry over into the criminal justice system. Now, we do have a different kind of set of rules that's similar on the criminal justice side. We call this competency. So let's say that someone is interacting with Sam and it seems like he really doesn't understand the charges that are against him or the process that he's going through, and he really can't help the defense attorney. There could be a process called, there could be a finding of incompetence to stand trial on the criminal side. So that's a great question, but it's good to keep in mind that guardianship does not protect somebody in the criminal justice space. And certainly we could talk about also the consequences of guardianship in the civil sphere. Okay, so let's keep going with Sam. Let's see what happens. So Sam finishes his 2 years in prison and then he gets released. Now, sometimes what happens when you're released before you've served your entire sentence, you'll actually be released under supervision of the state or the federal justice system. And in some places we call this parole, right? So we'll say that Sam was released on parole, which means he's under supervision. And whenever someone is released early or under certain conditions, they usually have to meet with actually a different type of criminal justice professional, sometimes called a parole officer. And sometimes we consider these individuals part of law enforcement. So Sam has to meet with his parole officer every other week. That's part of what he has to do to sort of meet his conditions. Now, what happens is if that doesn't happen, if Sam doesn't make it to every meeting with the parole officer, there could be consequences. Sometimes we call this violating parole if Sam, say, misses one of these meetings or does something else that he's not supposed to do. And one of the biggest consequences is Sam could end up back in prison if he doesn't follow every condition of parole to the letter. So it can be a really, really challenging part of transitioning back into the community, right? The person is no longer in the system, but now they're trying to get back into the community, and there's usually this kind of in-between step or phase before they can do that, where someone's under supervision. Okay. So then after Sam finishes parole, he'd be back out into the community and hopefully on to bigger and better things and not breaking into cars anymore. But let's look at the system from the other side. And I think this is a really good time to take a pause, and we're going to switch out the interpreters again. And Jaleesa, I'll just ask you to re-spotlight the right interpreter. And I'm going to hand things back over to Reggie.
All righty. Are we good to go for the next interpreter? Awesome. Well, thanks to Ariel, we have went through the stages of the criminal justice system for a suspect and defendant. Now we're going to go through the system again, but we're going to go over the process that the victim will go through. We have another story for you. Just like Sam, Linda is a person with a disability who got into a domestic violence dispute with her partner. Her partner hit Linda, and a neighbor actually heard the incident go down and called the police. Police arrived, to ascertain what happened in this situation. So we see in this version of first contact, a complaint was made and law enforcement was called to the scene. So law enforcement officer will interact with Linda or her partner and see what is the purpose of the call. Now, during this investigation portion, a law enforcement officer will interview Linda and just to get her side of the story about what happened in the fight. Usually in instances of this, she, or they may notice bruises on Linda. The officer may notice there's some damage around the household. And seeing this, the officer will refer Linda to a victim advocate, ensuring her victim rights, and also kind of just see what's the story, what's going down, and what actions needs to be taken at this moment. So during this process, the law enforcement officer has decided that Linda's partner is the one who instigated the assault and arrested and put her partner in jail. Now, through this system, Linda will have a prosecutor and a victim advocate work with her to help prepare her for trial. So working with the prosecutor will try to get Linda's testimony or prepare her to give her testimony. Now, what that is just having a formal or written statement that's given in a court of law. So this gives Linda the chance to give her side of the story and see and let the court know how she's been impacted by her abuse. There will also be a cross-examination portion of the trial where the defense attorney will try to poke holes into Linda's story just to damage her credibility in a sense. So the defense attorney will want the judge and jury to believe that Linda's story is not as credible as she claims. And I see that there is a question that was given, and I'm going to read that. So the question is, how do we help the criminal justice system when someone with a disability is arrested if they aren't a good self-advocate and self-disclose that they have a disability? I'm trying to bridge the gap here in my community. Well, I would like to take a stab at that, and everybody, you are free to chime in after I answer. Oh, the question's gone. Here it is. So, the burden of trying to find what happened shouldn't fully rest on the person with a disability. The law enforcement officer should have at least the training and the wherewithal to notice that if a person is not able to really speak up for themselves, to kind of look in more into a situation than to take it at face value. We noticed throughout the country that many law enforcement officers aren't fully trained in this area. So we'll put in a shameless plug for our Pathways to Justice program. This is where we train all criminal justice professionals, not just law enforcement officers, on how to interact with people with disabilities so they're able to look for certain signs and fully advocate them and protect their rights as individuals.
Yeah, it's a really strong, good question. So thank you for it. I'll maybe speak to the disclosure piece. You know, you've noted in the question that, like, well, what if people don't disclose that they have a disability? And, you know, Reggie made the point that we really want some of that burden to be on the system itself to identify whether someone has a disability and say might need additional supports to kind of get through the system in a way that's fair, right? Fair to them. I mean, the decision to disclose is a very personal one, and you don't have to disclose that you have a disability in any part of the system if you don't want to. But there is a catch. Often you have to disclose if you want a formal accommodation or support to be made. You might have to describe what you need. You might have to say more about your disability. It really, really depends on the situation. But that's something that is a very personal choice. I think probably what we see more of is individuals maybe not wanting to disclose if they're interacting with law enforcement, but maybe seeing more disclosures by the time they get to, say, maybe the trial, or they're working in kind of that more formal part of the system, and they might need some formal supports to kind of make it through that process. But it's a great question. There was also a question in the chat box that I'll just note about whether parole is something that can happen in the civil system. And the answer is really no. Parole is really something that's only on the criminal justice side of things. We don't really see that happening. But, you know, I could imagine if I was, say, like in a civil case because I'm suing somebody because they hit my car, it might be nice to think that that person would have to go under parole, but unfortunately, that's not how it works on the civil side of things. So parole is only on the criminal side of the system.
Thank you for these excellent questions. I know the Q&A portion is going to be really, really great. So we'll just move on to the next slide. So during trial, Linda has the opportunity to tell her story to the judge or give her testimony. And then she uses time to speak about the impact the abuse that she suffered has on her life. So during this portion, there is a victim impact statement where she's able to give out to court so the judge and jury are able to hear. And there will also be a sentencing phase. And the sentencing isn't for Linda, but the sentencing is for the defendant, how Ariel has explained previously in the story for Sam. So the judge were able to render their verdict, not the verdict, I'm sorry, rendering the sentence for the defendant. So you may have noticed that we have skipped the incarceration side for the victim. That actually was on purpose. For the incarceration portion, the victim has already been hurt by the crime, so we wouldn't want to put them in jail or in prison. So during the incarceration side, the victim has the opportunity to know when the person who has abused them or has hurt them know when they're released from prison. So this is just to notify the victim, so the victim is able to give any statement concerning that, or get the affairs in order and able to kind of cope with the person being released or transferred, or any situation that affects the defendant in moving or being released, and how that may hurt or affect the defendant. So for the transition portion, we see that Linda is struggling with what happened to her, and that's understandable. Being the victim of an incident could be pretty traumatizing for anyone, and healing is not just a one-step thing. It can take time. So the victim advocate is there to help Linda find resources and also find some measures to help Linda to not be a victim to this abuse again, able to help them kind of cope and heal from the pain that she has endured. So through that is what the victim of in the criminal, the stages that a victim will go through in the criminal justice system. So you see that there are differences for the suspect, defendant, and the victim. So I hope you all have gained so much valuable information from this. So you go to the next slide, Ariel. Oh, and it seems like the informational part of the webinar has been completed. Now we're moving on to our participant Q&A. So I will let the director, Lisa, to help us moderate the questions. If you have any questions, please enter them in the Q&A box at the bottom of your screen. And I see that some people have already began to do so. So, Jaleesa, do you mind showing yourself and kind of helping us moderate the questions?
And real quick, why don't we pause briefly so that we can switch the interpreters again while Jaleesa gets ready to moderate the questions for us. So we're going to pause for a few moments and allow our interpreters to switch off.
Okay.
Wait, interpreters ready to go? Perfect. Okay.
Okay. So the first question is, does having a disability give you protections as a vulnerable adult automatically or only in some situations? So that's just the first part of the question. I'll go to the second. Does being on disability / being legally designated as disabled give those protections automatically?
These are great questions. Reggie, you want me to take this one?
Yes, and I'll take the next one.
Perfect. Okay. So this is a great question to ask of whether having a disability gives you automatic protection. And the answer is it depends. It depends on what part of the system we're in and kind of what the situation is. When we're talking about the criminal justice system, generally speaking, if you're a person with a disability, you can't be discriminated against because of your disability. But there is a caveat. You know, the person has to know or have good reason to know that you have a disability in the first place. So if you're someone with, say, a hidden disability and there's nothing sort of outwardly happening that might signal that you have a disability, there isn't necessarily going to be the same level of protection. So what I was talking about earlier is sometimes in some situations, you might have to disclose in order to get some protections. Now, this is a great preview to our next webinar in the series, which is all about your rights as a person with a disability in the criminal justice system. So we're going to talk about things like certainly whether or not to disclose. We're going to talk about effective communication and what that means, and how to ensure individuals with disabilities have access to the justice system. So definitely join us for the second webinar in the series. We'll talk more about that. Now, for the second part of the question, if you're legally designated as having a disability, it depends, that's usually a civil designation. And it's usually because you're maybe receiving some kind of benefit or you are receiving services, say, through your state. Those are both civil situations, and that does not necessarily carry over into the criminal justice space, right? So let's say you're on SSDI or you're enrolled in the Medicaid waiver on your state, that doesn't necessarily translate then into the criminal justice system. Now, let's say you're a defendant and you're working with your defense attorney and you do disclose that you have a disability. It's possible the defense attorney might use that information to try and help your case. So especially if your disability had something to do with why you committed a crime or why you did what you did, the defense attorney might use that to try and help you. But at the same time, sometimes we see the prosecutor also using that information. This can happen in things like sexual assault cases or, kind of really kind of complicated situations where on the other side, the prosecutor might say, well, because the person has a disability, they are quote unquote more dangerous to society. So there are pros and cons to disclosing a disability, and certainly protections could come in certain situations, but also the knowledge of a disability could impact your case in different ways. So more to come in the next webinar.
The second question, do you know any data of how many people with intellectual disabilities who are borderline in jail system?
Okay, that's a good question. Yes, we do have data on persons with disabilities. Let me see the question. Yes, persons with disabilities, including those with intellectual disabilities who have been arrested and are currently, or who have been in jail or in prison throughout the system. If you would like more information, I encourage you to email us at nccjdinfo@thearc.org, or you can email me or Ariel personally at thomas@thearc.org or sims@thearc.org, and then we can actually send you the information that we've compiled, so you'll be able to, so we can able to go into that a bit further.
Next question. How do you know if a police officer is there to help you or arrest you?
Can I? This one? Okay. Well, more than likely an officer will state what they're doing. If they will have to arrest you, they will tell you you will hear your Miranda rights. If an officer is there to help you, an officer will normally state that. But we do want you all to be aware that sometimes it doesn't happen as well as planned. So we will also want you to know your rights as a person with disability in the criminal justice system. So as Eric had alluded to earlier about our second webinar, and that we can answer that in a bit more detail and about what are your rights as a person with a disability. But I do want you to understand what the officer is saying and kind of pay attention to what they're asking of you. Ariel, do you have anything that you would like to add?
Yeah, I think it definitely depends on the context of the situation. So let's say you were out and about in the community and maybe you fell over and you scraped your leg and then a law enforcement officer comes up to you. They're probably there to help you, right? Because there's something that happened, you just got hurt or somebody else got hurt. So that can give you a sense. But sometimes police are called in the community because people are just out and about doing things, any person would do. So we have seen situations where someone, say with autism, is stimming out in the community. Another community member sort of perceives that as strange or a weird behavior, and they might call police because of that, and then law enforcement shows up. In that situation, the law enforcement officer might be, asking you a lot of questions, right? Like, what are you doing here? Why are you doing whatever action you're doing? Like, should you be here? Where are you going? So I would say usually, if the officer's not in a helping place, they're often, I would say, asking a lot of questions. It seems like maybe they're trying to imply that you did something. And I would just say if you're not comfortable, you don't necessarily have to talk to the police. You can say, I don't want to talk to you. And, when we're getting to kind of, as Reggie mentioned, the Miranda warning, when an officer is actually preparing to formally question you, one of the things we always tell people is to say, I don't want to talk to you. I do want a lawyer. And that's all you say. And then you leave it there. And then at that point, the officer should not be questioning you any further. So context matters a lot. But I would say if the person is not there in a clearly helping capacity, just be aware that they might then be there because they think you did something wrong, and be careful with your responses.
Okay, the next question is, tell us more about victim advocates. Are they paid or volunteered, and are they available also in the juvenile justice system?
This is a great question. So it really depends on the jurisdiction or the community where you live. Sometimes victim advocates are professionals within an existing agency. So you might have places where a law enforcement agency has victim advocates as part of its staff, as part of its organization. Sometimes victim advocates are part of a prosecutor's office. And so they work alongside prosecutors to support victims throughout the process. And then there are also victim advocates that work from community-based organizations. And sometimes in community-based organizations, they might specialize in certain types of crime. So for example, there might be like a rape crisis center or a domestic violence organization. They might have advocates on their staff that specialize in supporting victims through different types of crimes or things that happen to them. So it really depends. I would say victim advocates within criminal justice agencies typically are paid. Certainly in the nonprofit space, they would probably be paid as a member of staff, but those same organizations might also work with volunteers. And certainly they can also exist in the juvenile justice system. So if you're in your own kind of jurisdiction, you could just do some searching on the internet of, victim advocates in X county and see what pops up. and you'll get a sense of who might be there.
Okay, the next question is, as someone who is a self-advocate, has high-function autism, also a victim, I never received a victim advocate nor collaborated with a prosecutor. I did press charges against the suspect, but nothing went through. I have had this happen to me 3 different times. I have prepared a written testimony. What can I further do?
I'm so sorry that happened to you, and thank you for sharing your experience with us. I'm going to have you reach out to us through our information and referral process. You can either email us at nccjdinfo@thearc.org, or if you can get onto the ARC's webpage and look for the criminal justice section, you'll find there is a request assistance form there, and you can let us know, tell us a little bit more about your situation, and we'll do our best to help you.
What type of resources are out there for people with disabilities who might have been unfairly convicted due to their disability, and years later, as a mature individual or elder, his conviction impacts his eligibility for housing, care, employment, etc.? Is the ARC a source for information and support?
So this, oh, sorry, go ahead, Reggie.
Oh, no, sorry, I didn't mean to cut you off.
Okay, you want me to go or you want to go?
You go.
Okay. Okay, so, you know, it is really challenging once somebody has been convicted to deal with the consequences of that conviction. There are some kind of limited situations where you might actually be able to overturn a conviction. So an example of this might be innocence, right? If the person actually did not do the thing they were convicted for, that is one reason that a case or a conviction might be overturned. Another situation is if they didn't have effective assistance of counsel. So if they didn't have a defense attorney at the time that was very helpful to them, and it's very, very difficult to prove, but it is a possibility to overturn something like a conviction. On the disability side, more specifically, often that alone will not be a reason to overturn a conviction. Sometimes like new evidence of a disability could weigh in, but then they might actually sort of go back and reopen the case, but it's very rare that they'll actually go and kind of overturn a conviction. We've worked on some cases where this was an issue where someone was convicted. We think the disability wasn't taken into account the way it should have been. And usually the option is, you know, doing those other arguments that I mentioned, or doing things like requesting a pardon from a state governor. It can be very, very challenging. So if you do have a specific situation and you are looking for additional information and support, I would also encourage you to visit our request assistance page on the website.
Next question is, there have been people let out of jail during COVID without notifying victims. People with disability will be more vulnerable. How can the ARC help?
Okay, thank you for that question. Well, we have different chapters all over the country. So first thing I would want to encourage you to do is to connect with your local or state chapter. And each chapter is a bit different. So you will want to inquire about the resources that chapter offers. So if you connect with your local chapter, they should be able to kind of give you more targeted information for the people, the vulnerable persons in your area.
Let me just pause here. Should we switch out the interpreter again? It's okay? Okay, we're going to go ahead and switch. So we're going to pause here and we'll switch out just one more time. Thanks for your patience as we switch. Okay, I think we're back and ready to go.
I work with individuals who have frequent encounters with law enforcement due to their fixation on going to the hospital. Due to this long-standing history, the police have a nonchalant sort of attitude towards emergencies at the house. Are there any suggestions to help dispel this attitude and mend that gap that seems to be set?
Well, I'll take a jab at this question, Ariel. This again is another shameless plug for our Pathways program. We have met plenty of officers who are called out to certain areas multiple times, and they are at times understandably annoyed and frustrated with having to go out to an area and they can't really do much in that given situation. So we do train law enforcement officers to take any matter that they're called out there seriously, and I'm sure that many officers do that, even if they are frustrated, because you don't know which situation could be an actual emergency. So we try to help officers understand the severity of the situation and why their full attention is needed, and not to just brush off any calls to an area that they may have visited or visit a person that they may see multiple times, because a situation can be serious. So we try to help bridge the gap. And what has been helpful in the past is kind of having victim advocates speak with law enforcement officers so they're able to kind of share ideas and collaborate amongst themselves, because even though they don't really work together, do their job normally, they interact with the same people multiple times. So if you have an advocate, just come in and just let them know the reasons why law enforcement should go out to a scene and not be so nonchalant about a situation, then that has helped, and many officers really do appreciate hearing this perspective from a victim advocate.
All right. The next question is, how long does an individual have in jail before they could lose their services?
That is a great question, and the answer is it depends. So it does depend on certain types of benefits or services or programs that they're enrolled in. It also can depend, of course, on the state and where the person is located. So certainly if you're working with an individual and you know that they're going to be incarcerated, especially for a longer period of time, that is definitely something that it would be helpful to look up specifically what programs and services that person enrolled in and what are the kind of the time frames. There are some programs that, once the person is released, they can sort of reapply or their benefits are reinstated, but many of the programs and services will require some kind of application process, or at least a formal notification when the person is transitioning out of, say, a prison and back into the community. Something that we've been seeing more is prisons and jails are trying to work with individuals to figure out what services they did have, and also what services they might need on the other side of being incarcerated. So it's certainly something that is really, really important, but it's going to depend on where you are, the specific facility, and the services the person has.
Next question. Can you please explain the limitations and/or the rights that a legal guardian have over the ward in a civil/criminal case or process?
So on the civil side, or excuse me, on the criminal side, next to nothing. As I mentioned before, guardianship does not, as a general rule, carry over into the criminal justice space. When we're on the criminal side of things, we are all responsible for ourselves, and that is the starting point for everybody. So there is no, sometimes we hear from folks, well, if I get guardianship over someone, can I protect them from criminal justice involvement? And the answer is no, you cannot. It doesn't work like that on the criminal side. Now, on the civil side, there are different types of guardianship. Guardianship looks different in every state, but there are generally two types. There's sort of what we call a plenary or a full guardianship, and this means that the guardian would have sort of full decision-making power over all aspects of civil life. So this could be finances, medical decisions, where the person lives, those types of things. But we also have limited guardianships. So these are guardianships that are sort of narrowed in on a specific area of life where the guardian will make decisions for somebody. So someone under a limited guardianship, say the guardian might only have power to make financial decisions. Now we're talking about guardianship, but really the best practice in this space to support anyone who might need help with decisions is supported decision making. I would encourage you to visit our Center for Future Planning website on the ARC National. They have some really great programs and information there about supported decision making, what it is and what it can look like. Because at the end of the day, we do want people about whom the decisions affect or impact, we want them to have the final say and choice. But that will be a great resource for additional information.
What do we call the individual who advocates for an individual with a potential hidden disability whose crime may have been due to their disability? Not a victim advocate, but a...
I think that would depend. So there is no sort of formal name or one consistent name for somebody who might be advocating for somebody in the criminal justice space, especially if they have a hidden disability. Certainly within our network, we see chapters who are advocating for people every day. I think, some of them call themselves advocates. Maybe some of them are calling themselves support people. If you'd like, if you provide those types of services or advocacy, feel free to put in the chat box for everybody if you have a particular name that you kind of give yourselves. But there isn't sort of one formal name or option, but hopefully you'll get some thoughts in the chat box about what people do call themselves who provide this type of service.
If a person chooses not to disclose a disability when they first enter the court system, is it more difficult to receive screening or accommodations later in the process?
I would say generally yes. Kind of the further you go into the process, the harder it can become to get supports. So it is better the earlier that the disability can be identified. But that being said, that doesn't mean that we think individuals have to disclose. We do want to put that burden back on the justice system to be sort of the one kind of making sure that everybody that they're interacting with who might need services or supports is getting those services or supports. But certainly, again, it's a personal choice, but it can help you get accommodations and supports. And if you do plan to disclose your disability, I would certainly probably say it's better to do it earlier in the process rather than later.
Okay, let's see. So if you cannot be discriminated against for your disability, sorry, how are people being charged for behaviors that are because of the disability, including children in schools being arrested and charged for behaviors documented in their IEPs?
Oh, there. That is an excellent question. And I'm just rereading your question just to make sure that I don't miss anything. Okay. We do want to say that people with disabilities, are able to commit crimes. We aren't advocating for, the discrimination of people with disabilities. We will want the criminal justice professionals to understand that sometimes a disability may exhibit behaviors that just
You want me to jump in here?
I think I got it, but you can jump in one time then. Sorry. So we don't want to, say that people without disability, people with disabilities aren't able to commit crimes, because that's not true. But we know that the justice system legally isn't allowed to discriminate against persons with disabilities. But we know that that's not the case all the time. And this is why we're bringing attention to this, so people with disabilities are able to understand their rights, because some individuals may not have their best interests at heart or may not do what's right by them in this system. So I'll give it to Ariel, which he'll be able to answer.
Yeah, I mean, there's kind of the short answer is, in a perfect world, no one, child or adult, would be arrested on the basis of their disability. That should not happen, right? That would be discrimination. The problem is on the sort of the back end, proving that that's why they were arrested, that it was because of their disability and not something else, or something that was related. Now, specifically in the school context, there's some additional kind of challenges, but also protections for students with disabilities. So in the school space, we're talking about typically the Individuals with Disabilities Education Act, or IDEA. And if students do have, say, behaviors related to their disability in their IEPs, as you've suggested in the question, then when a student does manifest that behavior in a classroom, the school has a responsibility to follow the IEP, or more commonly a behavior intervention plan, or BIP for short, because who doesn't like fun acronyms? Now, if the behavior is documented, that should trigger what's called a manifestation determination, where the school is supposed to investigate whether the behavior was related to that child's disability. And if so, then it should be resolved in the academic setting, and that child should not be kind of referred out to the juvenile justice system. But in all of these laws, there's always sort of this exception for safety, or if someone is presenting a direct threat, right, or posing a danger. So sometimes what we see happening is, if somebody is like throwing a chair, it's related to their disability, but the teacher feels like their life is threatened, or that the lives of their students are threatened, that might kind of go around the process. But there still should be that determination about whether or not it was related to the child's disability. The IDEA and kind of what happens in schools can get very, very complicated. I do encourage you to check out the ARC at Schools website for additional resources and information about IEPs.
Next question. Do healing services let all victims know of release date, or just domestic dispute and violence? Is it always in writing?
This is a great question, and the answer again is it depends. So it depends on the system, it depends on the crime, and it depends on the sort of the process in that particular jurisdiction or state on how victims get notified. So there are certain crimes that usually often come with much stricter notification requirements. So for example, if you were physically or sexually assaulted by someone, those typically will come with more stringent kind of requirements that you be notified if the person who harmed you is going to be released from prison. But it really depends. And something like a property crime, like coming back to our cell phone example, probably not. You're probably not going to get a notification that the person is out of jail or prison.
I would also like to say these have been excellent questions, and I've really enjoyed this portion of the webinar. But we are running low on time, so if we haven't been able to answer your question, or if you don't feel comfortable kind of asking questions in this kind of public platform, then I will encourage you to please email us at either nccjdinfo@thearc.org, and I will go on to show me and Ariel's email, so you're able to email us personally, and we'll be able to answer your questions in great detail, and we're able to give you much more attention in this webinar. So I want you to join us for our next webinar, Know Your Rights as a Person with a Disability in the Criminal Justice System. During this webinar, we'll go over your rights as a person with a disability in the system, and how you'll be able to know what your rights are, what our disability rights laws are, and how to fully advocate for yourself as a person with a disability. So I hope you'll be able to join us on June 4th, 2020 at 2 o'clock p.m. Eastern Standard Time. We will also post different times if you are in another time zone. So just please keep an eye out for that. Thank you again for joining us today, and we really hope to see you next time. Eric, can you go to the next slide? Here is our information. Here is my Ariel's and our director, Leanne Davis. If you have any questions, please feel free to email me or Ariel, and we'll be happy to answer them. Thank you again for attending this webinar, and I hope you all will have a good afternoon.
Thank you, everyone, for joining us. And quick thank you to our interpreters and to our captioner today. A round of applause. Have a great day.